we're going to share with you guys something that we know is going to change your life if you qualify. Now, we know everybody don't qualify. Everybody don't have what it takes to go to the next level of what I call standing up to your rights, standing up for your own rights. Yeah. You know, it took me some time to get there. It was like riding a bicycle, falling off my head a few times. I know it took you some time to get there. You had your fears. So we understand the fear factor when you go to court. But we're here to tell you, when you got the right ammunition, fear factor stays outside of the court, doesn't go into court with you because you're in control. And I know everybody know about control. When you're in control, you're in the driver's seat. So today we're going to keep it real. We're going to share with you guys how to win tickets. And we're going to pretty much just chop it up and let you guys, know what to do and how to do it. So, what you think, Todd?
Well, the first thing people need to realize is that only sane and belligerent people exercise their rights. Everybody else waives them. And when you go to the courtroom and you don't know what you're doing, you're going to waive a lot of rights and you're going to possibly lose your case.
Okay, now say that again a little louder this time.
Only sane and belligerent claimants exercise their rights.
Now, what does that mean? What do you mean by that?
Well, you have to be sane, meaning that you have sound mind, and you have to be belligerent. You have to be bold enough to state your claim. And if you're not bold enough to do that, you're going to waive your rights. And when I say rights, I'm talking about constitutional rights, I'm talking about civil rights, or whatever else you may have in jeopardy. And you might find yourself in a situation where you end up paying a lot of fines that you don't necessarily have to.
Because of fears?
Because of fears and ignorance.
Okay, so basically he's saying, for a bunch of you chicken shit motherfuckers, we understand, because, at some point, we were scared shitless too. But, we woke up. We said, you know what? Them stinking skin mother suckers got on pants just like we do. They shit like we do. So we're not gonna sit here and keep taking it up the ass, giving up our hard-earned monies because of fear. So basically, all you got to do is, put that fear shit to the side. You can get bold and cuss out your fiance, your girlfriend, your boyfriend. But when the time to come in front of them motherfuckers who taking the money out your pocket, you coward. We're saying, forget that. Stand up for your rights. Get strong and do what the hell it takes. And we're gonna show you how to do it.
Okay, that's correct.
We can do that?
We can definitely do that.
All right. Now, what's the first thing you would say people want a question they would have when it comes to going to court?
Well, the first thing is when you get pulled over by the police, you have to understand what it is you're actually getting. You're getting a traffic citation, which is claiming that you have violated some provision of the vehicle code. So if you're in California, you're getting a traffic citation that's claiming you violated, say for example, you were driving a suspended license, they're claiming that you violated California Vehicle Code section 14601.1. So now your response to that, first of all, should be, what is the traffic citation?
What is a traffic citation? Is a traffic citation a promise for you to pay something when you haven't injured anybody or hurt anybody? I mean, is that what a traffic citation is?
Well, actually, the traffic citation is an administrative agency claim that you have violated some provision of the code. Now, when I say administrative agency claim, who's the agency?
Wait a minute now. Hold on now. See, y'all think he's talking about the court. Y'all think he's talking about the judicial body. That's not what he's talking about. He said administrative agency. In other words, you're talking procedures there.
Yeah, I'm talking about the procedures. So the agency is the Department of Motor Vehicles, who has the original and primary jurisdiction over traffic.
Stop right there. Now, what he just said, because I know this language is foreign like a motherfucker to some of y'all. Okay. He just said, all right, I got to break this down in layman's terms. The traffic citation, the only people who have the authority to write or administer that traffic citation is DMV. DMV goes through California Highway Patrol or any other police departments who are writing those citations.
So they're acting as agents on the behalf of the Department of Vehicles.
So he just said now, because I'm breaking it down, because I know y'all don't understand this shit. There are sub-agencies to DMV.
Correct.
Which they write on behalf of DMV.
That's correct.
Not the courts, because y'all think the citation is based on the courts issuing that shit. You wrong. You's a dumb motherfucker. You wrong.
So what happens when you get the ticket is the sheriff writes you the ticket, you sign a notice to appear that you get there, and then what happens is the district attorney's office collects those said traffic tickets and files what's normally called a verified complaint.
I know y'all know what that is. What's a verified complaint?
A verified complaint is a complaint that's stating that you've broken some law, and it's criminal now. You're in criminal court.
So that little citation became criminal once they wrote it as a verified complaint?
Yeah.
Now y'all criminal, that's criminal. But wait a minute. They execute some of them as infractions. Like for my case, I had 4 charges. They executed them as infractions. Failure to appear, no driver's license, no seatbelt, and they were executed as infractions. How is that if they're criminal?
Well, actually, once the district attorney files the criminal complaint, they put you in criminal court. So
that was a trick right there.
Go ahead.
No, go ahead.
So they have you in the criminal court, so you have to respond to the criminal charges. Now, what they have you do in there is they have you answer the complaint with the response of guilty, not guilty, or no contest. See, so if you were trying to challenge the jurisdiction or not fight the ticket, you've already kind of like walked in the court and acquiesced that you are the defendant, even though you haven't done anything. You haven't done any crime.
You haven't committed a crime.
Right.
So what he basically said, guys, is the moment you give way to the citation without understanding the rules and procedures, you in essence give up jurisdiction. They don't automatically have jurisdiction. They have to establish it and prove it. And since procedures dictate that they don't have it, but you don't know that, you actually give it to them by participation.
That's absolutely correct.
Wow. So what we're here to show you is stop giving up jurisdiction. There's procedures, there's steps. If you can listen and learn a little bit and get over your damn fears, we can show you what we're doing that works. You can do the same thing. Now, some of y'all, we might hold your hand, but most of y'all, we're not. You know, this ain't for everybody. We understand that. You got to have heart. You know, most people all talk and no heart. See, we've learned, so the talk is out the window. See, we can tell you what we know because we got heart. You know, what's coming to you is pure heart. Ain't no fear. You know, we do this shit for fun. We're not telling you to do that. We're just telling you to exert your rights. Okay, Tom.
So the first thing I do is I have a motion that I file with the court. And what I do is I file, well, once I get the ticket, I know when I go to court they're not going to be ready to file it. So I go to court and I ask for a continuance because I want to file my motion to just a motion to dismiss with prejudice, basically. So, and then what I do is I file the motion, and then when my next court date, I get to argue the motion. However,
now is that an arraignment?
At the arraignment,
do you file at the arraignment or before the arraignment?
If I know the case number and everything, I would file before the arraignment.
Now I use the citation number as my case number. It has never failed me.
You can do that.
So that I can get my paperwork in time, because I've experienced not getting my paperwork in and the ramifications of that, which I'll share later on.
Right, but once they know that you're, see, the key is you want to take this out of the jurisdiction of the court immediately. So what I do is I'm arguing, it's a spin on the right to travel. Many of you have tried to argue the right to travel, and it's a constitutional argument that they really don't listen to in the court.
Bullshit.
But you know, so what I tell people to do is I use that because when they charge you with a crime, they have to actually convict you of all the elements of a crime. So for example, in my case, I was charged with driving a suspended license. So this
same here.
So California Vehicle Code section 14601.1 states, no person shall drive a motor vehicle when their license is suspended. So in my motion, those are all rebuttable presumptions. Right. So my motion states that I'm not a person as defined by the statute.
Now this is legal because if you look in Black's Law Dictionary, it will tell you the definition of a person is totally different than the definition of a person in a regular dictionary.
That's correct. And I also dispute whether my family automobile is the state motor vehicle.
Meaning?
See, the state motor vehicle has to be used for commercial purposes.
Now, some of y'all know this, some of y'all don't. What he just said was, if you give way that your vehicle, if you give way to the law that states that your vehicle is commercial when it's in your private use, then you a dummy.
Right. That's absolutely correct.
He doesn't do that, nor do I.
So you have to be very careful to understand that words that you think mean certain things don't mean the same thing in law. For example, they'll try to trick you in court. They'll say, well, though you have a passenger vehicle. I don't have a passenger vehicle. Did you have any passengers in your car? I don't have passengers because passengers are people who pay to ride. I have guests that ride for free. So you have to be able to articulate that.
Hold up. Okay, I know some of y'all got that. This shit's simple. I mean, he just said people who ride with him, they're not passengers. that terminology has a meaning in law that's different than it is in regular life. That's why they said passenger.
Yeah, I never have passengers. So, and also I dispute whether my license is actually suspended. Now you can look at the records and see my license was suspended, but that's irrelevant. It doesn't matter whether the license was suspended or not. So
wait a minute. Why doesn't it matter whether your license is suspended?
See, because my license doesn't matter whether my license is suspended, because I already know that the DMV has broken certain laws by bringing this to court prematurely. So I don't care what they're charging me with, but we'll get into that later.
Okay.
So once I give them this argument, this is something that the traffic court can't hear. This argument, they can't hear this. See, because now I'm disputing something that has to be dealt with by the Department of Motor Vehicles.
Okay, stop right there. Basically, all he said is the traffic court, since they don't have jurisdiction, it is not within their parameter to even hear or see the case, because the procedures have been still violated or not addressed.
Exactly.
So the court can't proceed where they don't have a right to. Again, I like to break that down and read what the law states, but I'm not, because we're too far ahead of ourselves. We're basically giving you guys an overview of how the documentation truly works.
So then, I'll actually even play with the judges sometimes, because see, a lot of them are actually bored and they like the dialogue. So I'll ask them, do you have an opinion of whether I'm a person that's defined by the statute? Do you have an opinion whether my family automobile is a state motor vehicle? Do you have an opinion of whether my license was suspended? And usually the judge is like, well, yeah, I'm looking at your DMV record, and yes, it shows your license was suspended. As far as I'm concerned, you're a person. You're standing here, and you got your car registered as a motor vehicle, so it's a motor vehicle. And see, my attitude is, it's not the use of the property that determines the status. I mean, it's the use of the property that determines the status, not how it's registered. But even though he's saying all that, I always tell the judge to say, you know what, I just asked you as a courtesy, because your opinion is actually unwelcome. And then I show him the laws that show him that his opinion is not welcome, and that is California Government Code. What's the code? 11340.1 in the California Government Code. It states that it is the intent of the legislature that neither the Office of Administrative Law nor the courts should substitute their judgment for the rulemaking agency.
Now, all that means is you can't change anything. You do not have the authority to judge, to change anything when it comes to this particular argument in law. See, that's law.
Yeah, so you have to give them the law. That's what they understand, that's what they respect. So now I'm hitting him with the code that says, it doesn't matter what you think, even though you're the administrative law judge or you're the commissioner. You can't substitute your judgment for the rulemaking agency. The rulemaking agency is who? The Department of Motor Vehicles. So now they don't know what to do. So wait a minute, I'm in traffic court, which is criminal, but I'm talking about something that he doesn't have a grant of statutory jurisdiction to argue in the court, and even here. So now he doesn't know what to do with me. So his next step is to either try to trick me into a pleading and stuff like that. But my point is now, I'm like, I can't even issue an answer to their charges. I'm not going to plead guilty, not guilty, or no contest, because the jurisdiction is in question because the Department of Motor Vehicles has skipped certain steps. And these steps are spelled out in the California Administrative Procedures Act, and every state has an Administrative Procedures Act that all agencies have to follow. Now, when an agency has a claim, whether it's the vehicle code, or whether it's the DMV or any agency, any state agency, they have to adjudicate that claim according to state law. And that state law is your state's Administrative Procedures Act. And when you look at your state's Administrative Procedures Act, it'll tell you the steps that the agency has to follow. Now, the minute that agency skips some of those steps, it creates a due process issue.
Okay, now, I'm glad he said that. This is the ticket to where we don't want to lose anybody. Where we're at right now is the difference of a win and a lose. What you understand about what we're saying right now is the difference of a win and a lose. When you understand this documentation, you can't lose. You see, because not only do you gain a power of understanding, you gain a true power of knowledge, of what it means to have knowledge. And inside of you, you change because you know what you know the judge don't know. But they do know they can't proceed because of what you know. And as he stated, they have no grounds to even hear your case. And I'm going to share where I've gone to court And the judge could not even talk to me about my charges. He couldn't say anything because of the documentation. He had to dismiss the case. 4 charges. He had to dismiss.
Now they have several options. Number one, they can dismiss the charges. And what you want to do is you want to let the judge know that you're actually hoping that he rules against you. And the reason I always tell him that is, I tell the judge, I say, you know what, Your Honor, I'd really like to adjudicate, I'd really like to, argue this case, but it'd be in your best interest to let me go. Because when you throw your broad net in traffic trying to catch people, sometimes you catch somebody like me who's like a barracuda. You don't want to get bit. Everybody else is tuna. So, and arguing with me will make you, they have far more to lose than I do. See, because now their revenue stream can be cut off. They could care less about my little $1,000 ticket, $500 ticket, but if you let me argue this and you rule against me, guess what? Now I get a chance to appeal it and get it on court of record. And then that judge is going to be in trouble because they're going to be like, why you didn't let this guy go?
Now, what he basically just said was, he wants them to rule against him so he can get it as an actual case law ruling. Once that transpires, now these judges are stupid. They're going to throw it out because they don't want that to happen. Because it becomes a record. Anytime you create a record, someone else can use that record. Right now, when they throw it out, there is no record. Period. So that means until you get a judge that will railroad you with this kind of documentation, which I don't think is going to happen, but it could, because you got some real dumbass judges who will do that. But until that happens, they're going to do just what they've done so far in all our cases. They're just going to throw them out.
You just throw them out. Now, you also want to give him you don't want to anger the judge also. So you want to give him an out. You want to give him a way to get out of this and save face.
Humility.
So what you tell him is, Your Honor, like I had a judge tell me, he says, what you're saying, Mr. Lynham, is we can't argue, we can't prosecute traffic tickets. I'm saying, no, Your Honor, I'm not saying that. I'm saying you can't prosecute my traffic ticket. See, you don't have to take judicial notice of the paperwork that I'm put on and apply it to my case, but you don't have to apply it to anyone else's case in the courtroom. And some of these people are right here listening, but see, the key is only you and I know what I'm talking about. Everybody else doesn't really understand.
That's just like if you're executing your constitutional rights and everybody else around you isn't, technically they don't have rights. The only person who have the rights are the person who knows it and who utilizes and execute it. Because remember, the judge's oath is predicated upon your rights. If he violates your rights, he's violating his oath. See, he understands that. That's why Todd makes the argument, I don't care about the rat-ass dummies around me. All I care about is moi in front of you executing moi's rights. So understand that. You have no rights if you don't know they exist. And do not stand up to them. In his case, or in my case, we have rights. And that's why we prevail. And we're only going to help a few people who want to prevail.
Now, let's say you do get to the point where you actually get to argue your motion. You filed your paperwork. You've got a motion here. Now, when you file your paperwork, there's certain rules of court. You have to file your paperwork within 10 days before your case is be heard, so that you give the opposition a chance to respond. Now, they have to also do the same thing. They have to file a written response to your motion.
Which never, ever happens. Now, guys, I got to say this before we continue. This is just another way to get the case thrown out. I mean, there's so many methods by which this documentation work, it ain't funny. See, we learn things as we go that they're supposed to do. That's the beautiful thing about law. When you're in tune to law, you're going to see things that you never saw before. You're going to see new loopholes and ways out or violations that they're committing every day. But since you don't know it, it's not a violation committed.
So the district attorney's office, because what normally happens is the district attorney is only acting on their administrative duties. They're just bringing the cases to the courtroom, and then they're letting the judge issue the penalties and fines. Now, when they see your motion in the file, they're going to be like, oh, whoa, I just see this 20-page motion here, and I just got this morning. But it's not my fault that they didn't look at the file early and file the written response. I actually served it on them 10 days in advance. But because they did not file written response, so what they'll do is they'll come there, they'll say, well, I'm not ready, Your Honor, because I just got this paperwork. Now, when I was inexperienced, what I would do is I would give them time. And then what ended up happening was every time I came to court, it was a different assistant district attorney, and they were like saying, I just got this. And
In other words, they bounced different attorneys in to continue to buy time because they didn't know how to answer the paperwork. And they never will.
So you can do two things. You can ask the judge to dismiss the case based on the fact that your motion stands unopposed. And now sometimes the judge will rule against you. He'll try to rule against you, but then if he's ruling against you, he's actually serving as the opposition. He doesn't, there's nobody, your motion's unopposed, so it's kind of like it wins automatically.
Well, okay, well, now how does that apply when there isn't a state attorney? Because, in a lot of states, some states, there are no state attorneys that are arguing. So what rights does the person have? Because I know the judge never responds when there is no state attorney.
Well, if there's no state attorney, then there has to be an opposition party.
No, it's the judge. The judge has the right to act in more than one capacity, even though his oath of office says...
That's a whole other animal now. He's acting in two capacities. He either has to step down off the bench or he has to come down and be the opposing party. He can't do both.
Okay, wait a minute now. So you're saying that if you're in a state and the judge is acting in more than one capacity, he's in violation of his oath of office.
He's supposed to be impartial.
Okay, let's get beyond that. Let's just say, okay, the person don't want to argue that argument. What can they do if the judge don't? The judge still has to respond as a state attorney will respond, correct?
Okay. So is he going to file a written response? So okay, this is the case. If the judge tries to rule, he tries to argue against you. You have to say to the judge, well, in California, it's a court rule. It's California Court Rule 4.111, subsection A, that states that they have to file a written response to your motion. So you don't have any grounds to even argue this in my case against me.
Now he said California Rule 4.111, subsection A, basically means the opposing side has to respond in so many days to the documentation that you file. If they don't, and since the judge is by himself and he won't, what happens?
He can't argue against you. He cannot argue because now you're at a disadvantage. See, law is based on fairness. I show you my hand, you show me yours.
Wait a minute, stop. You know what you just said? You basically just said if the judge is not, since the judge oath dictates that he can't act in more than one capacity, and you file this documentation, and let's say California has a rule that will allow the judge to act in more than one capacity to get the truth. But if you file paperwork, he can't file back because now he's truly acting in more than one capacity.
Exactly.
But he's acting as a state attorney.
In California, they do have the assistant DAs come in, but see the problem.
But not all areas. Downtown Los Angeles, there's never, in your case right now, there will not be assistant attorneys show up. Guarantee it. They've been making money too long. And in my case, assistant attorney never showed up, and I had two different cases. So what does the person do if the judge is acting in more than one capacity? They file documentation. The judge doesn't respond. What do?
So you have to recuse him if he's going to act in more than one capacity. Because now that you can't get a fair trial there.
Well, wait a minute now. I had him shift me to 4 different judges in one day. 4. It ended up the judge acting in one capacity. 4 different courts in one day. There was never a state attorney. So what should I have done? I would tell you. I know what I should have done.
What should you have done?
I should have filed my documentation, but prior to my court date, I should have filed for a default because the judge has to respond according to the rules of procedure. Now, that's if I played by the rules. But if I stuck to the documentation knowing that he couldn't answer it, I didn't have to give him jurisdiction in the first place. Right? So this is twofold. I have 2 choices here. Knock him out with the documentation. Do not give up jurisdiction because he doesn't have it according to procedures. Or just for the sake of argument, file a documentation that says, well, you've broken 4.111 subsection A because you didn't respond.
Right.
Correct?
Correct.
I have 2 options there.
It's 2 options.
Let me ask you this. Did I give up jurisdiction in any one of those options?
No, you did not.
Get that, guys. I never gave up jurisdiction. Even if I filed documentation, I never gave up jurisdiction.
Now, here's the crux of our argument. In order for the DMV to adjudicate their claim, in order for the courts to act, there has to be a final determination of facts on the stuff I was talking about me having whether or not I'm a person as defined by the statute, whether my family automobile is a state motor vehicle, and whether or not my license is suspended in my case. So the court can't determine that, not in traffic court. The DMV has to give me an administrative hearing. And so the court has to sit in judicial review of that DMV hearing. But what you have to point out to the court is, if they look in the file, there's no final determination of facts from the DMV.
Now hold on. I don't think y'all heard him. This is good shit. What he said was, in stupid terminology here, okay, he said he go to court, but he can't go to court because DMV has not adhered to the procedures that are set forth that grants jurisdiction to the judicial branch.
Right. Right.
Since that never transpired, guess what, guys? The judge can't hear the case ever. Never. No matter what you say, he can't hear it, and he knows it.
But he's not gonna let you. He's not gonna let you know he knows it. He may grin, he may smirk. I've had him do that. But see, the point I always make is, it doesn't matter what section of the vehicle code or penal code I broke, because the Department of Motor Vehicles is breaking sections of the California.
Hold on, y'all didn't hear that. Y'all didn't hear that. Let me tell you what he just said. He said it doesn't matter what vehicle code, statute, any section of law that he broke, it doesn't matter. Why doesn't it matter?
Because the DMV is breaking laws themselves.
Because
they broke them before I did.
Hold on. Because the governing body that issues the citation breaks the law first. In the first instance, they break the law.
So you have to. So you have to make sure you tell the judge that we can't even hear what I did until you satisfy the due process issue created by the DMV, allowing the sheriff's department to issue the tickets and the district attorney to collect those tickets and bring you to traffic court without giving you your administrative hearing. Now, trust me. Now, the first thing the judge is going to say is, well, how did we know you were going to argue this? You didn't. You didn't know I was going to argue it. But now that you know I'm going to argue it, you got to get it back to the DMV. So you got to get it back there now.
Y'all don't have a clue what he just said. I know y'all don't. Say that again, Kyle. Say that again.
See, the court doesn't know you're going to file this argument because everybody else just acquiesces. Comes in there, pays their fine, whether it was driving with no insurance, your registration was expired, your driver's suspended, doesn't matter. Because now you have to. What I'm doing here is showing the court that I broke that law with impunity. I broke it with impunity.
He said impunity.
I broke it on purpose. I mean, I was driving around with a suspended license for years, and it was like, if I get pulled
still
over,
am.
If I get pulled over, I know what to do because I know the DMV is going to break the law first. Even if I'm breaking it on purpose, it doesn't matter because now they can't they don't know how to prosecute this case once the paperwork hits. See, so they don't know I'm going to file this, but once they see it, they're like, oh my goodness, this guy's arguing administrative law. He's not arguing the facts. He's not saying whether his license was suspended or not. He's not questioning whether he was speeding or not. He's saying the DMV broke the law. Wait a minute. If the DMV broke the law, they can't accuse me. You can't hold me accountable for me breaking the law and then let the DMV break the law and not hold them accountable. See, and so you'll have judges say, well, our judges or district attorneys will say, well, the penal code and the vehicle code are the controlling laws of this case. That is true, but it's deceptive. It's clever but inadequate. See, because...
Oh, wait a minute. How is the California vehicle code statutes, how are they primary when they don't fall under procedure in the manner in which they should? Procedure supersedes
exactly
those particular codes.
Exactly. See, so what I'm saying is those laws are they are the controlling laws.
Okay, the controlling laws.
But the DMV still has to adjudicate their claim according to state law. And if they don't adjudicate their claim properly, it doesn't matter.
You know what he just said? Even though he said those statutes and vehicle codes are the governing rules, they still don't stand up to procedure. Basically, guys, you know what? They can write them all day, but there still has to be a process for them to even come into effect to have their merits. That's right. They don't have merits until the procedure has been accomplished that gives them their merit. That's the key.
Now, in order to win your case, you have to stick to your guns, no matter what. You cannot back down from the fact, because they will do a lot of stuff to you. I had a judge try to charge me with a habitual traffic violator, which is like I go around breaking the law on purpose, and that involves a year in jail. But you have to stick to your guns and know that it doesn't matter what you did because they've lost jurisdiction because the DMV didn't do what they were supposed to do.
So they never ever have jurisdiction to hear your case
until you actually give it to them. until you back down and cower out and say, okay, you know what, I'm going to go ahead and plead.
Chicken shit.
Yeah, don't do that.